Please be seated. Ladies and gentlemen, thank you so much for your extreme patience. We had to send out for copies for all of the instructions, and it took longer than we thought. Let the record reflect the presence of the jury, all counsel, and the defendant. Ladies and gentlemen, both the state and the defendant have now rested their case. The attorneys will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in your understanding of the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Mr. Sprouse, you may proceed.
Thank you, Your Honor. May I have the podium?
Yes. The podium or the table?
The podium.
Okay, yes.
Ladies and gentlemen of the jury, thank you so much for your patience. It's been a long day, but we put a lot of effort into today, so you don't have to come back tomorrow. Today we've been talking about State of Florida v. ALISHA. We talked about the charges of trafficking. I mentioned in my opening that there are 3 elements to prove the charges of trafficking methamphetamine, 28 grams or more, but less than 200. The first element that the state needs to prove is that ALISHA Marine Dean possessed a substance. The second one is that the substance was methamphetamine. And then the third and final is that the methamphetamine weighed 28 grams or more, but less than 200. As far as the last 2 elements, those are undisputed. You heard the testimony of the FDA lead analyst, Stephanie Spiegel. She testified that in her opinion, after she ran a gamut of tests on the suspected methamphetamine, that she in fact confirmed that it is methamphetamine. She told you how she weighed the substance and that there is a margin of error because of certain anomalies of moisture, temperature, etc. So, if 2 of them are undisputed, there is an argument, and we're just arguing about the first element, possession. You heard from Sergeant Gingrich, who started this whole investigation. She got complaints from citizens, concerned citizens, neighbors, Crime Stoppers, conducted an investigation, got evidence, applied for a search warrant. It was approved, and unfortunately, she didn't execute the search warrant because she was busy helping South Florida with the hurricane. But that search warrant was executed, and you heard about the execution of that search warrant from Investigator Aaron Pittman, Lieutenant Joseph Gordon, Investigator McFall, and Investigator Paxton. Some key facts. We talked about the search warrant. We talked about what we found from the search warrant, where we found it, why we're associating the ounce of methamphetamine to the defendant. For one, the ounce was in her dresser, in her room, in her RV, and there's no other evidence of people living in that RV, having access to that RV other than when Miss Alicia Dean is there. As soon as Lieutenant Gordon walks into the RV, he sees this table. You heard him point out what's on this table. Got meth pipe, filter for the meth pipe, green leafy substance, and then all the way up there, it's like empty bags that previously contained narcotics. Now, the only meth that was actually found in that camper was in the defendant's dresser. If the defendant does not know about the methamphetamine that is in her dresser, what's for the meth pipe? That shows that it's not a mistake that there's an ounce of methamphetamine in her dresser. What also shows it's not a mistake is the text messages that we saw today, that Lieutenant Gordon went over with us. It's not a mistake that somebody has an ounce of methamphetamine in their dresser when a few days prior, they're asking for an ounce of methamphetamine. And it seems that she got what she asked for. The other text messages are her trying to distribute and sell narcotics. Now you're going to have the text messages in their entirety. They're going to go back with you. There's 5 conversations. Andy, James, Ryan, Kid. Aunt's tap. Those are the 5. So I implore you, go through those text messages. One of them is much longer than the others. It's like 88 pages. And those text messages appear they're from the person that she's alleging was using her phone and setting her up. But that doesn't make sense, because why would somebody be texting with 2 phones right in front of you? Are you going to let somebody set you up right in front of you? That testimony doesn't sit well. Doesn't make any sense. It's not disputed that this is Alicia Dean's RV. Her name's on the wall. Her important documents are there. 7, 8 credit cards of hers are there. Here we go. So inside of the brown bag that investigator Pittman found, he found an ounce of meth. It was organized in a number of bags, and there's a receipt from the day before from Walmart. What that shows is that there wasn't a bag of meth just sitting in the camper idly. It hasn't been there for months. It hasn't been there for 4 months. She knew it was there. The day before and the day of. How do we know that? Well, the text messages, she's selling drugs on those text messages. She delivers. She has other people deliver. She's working in concert with another drug dealer. All of that goes to show it's not a mistake that there's an ounce of meth. She knew that the ounce of meth, how is she going to sell the drugs if she doesn't know where they are? It just doesn't make sense. This is the lab report that we went over already. It's going to go back with y'all. But that just shows it's undisputed. We are arguing about the first element of possession. Undisputed that that's her phone. She's arguing that other people use her phone. But when you look at those photos, it's selfies of her and other people together. There's not somebody just taking selfies and using her phone without her permission. It's just pictures of her in that RV. And there's pictures of her in that RV. There's not a party going on. It's just her. At most with one other person. Can I get a quarter ounce for $100? That's somebody sent a text message to her. The text messages that we went over, are you good? You know, they didn't have to talk about it. They've already done business together. That's what Lieutenant Gordon was saying. They're talking because they already know, they're familiar with each other. This is not the first time they've done it. This is not the first text they shared. We're arguing about first element possession. Laser focus on the first element. Cell phone download. Proximity of the drugs. Access to the drugs. It's not a mistake that there was an ounce in her dresser, in her RV, in her room. I want you to use your common sense. The question is, did Miss ALISHA Dean know that an ounce of methamphetamine was in her camper? She's a user. She's admitted to being a user. Well, used to be a user 2 days before. So I'm going to ask you to consider all the evidence that has been presented. Consider the testimony that has been before you, and I want you to find the defendant guilty. Thank you.
All right, Mr. Nopes, you may proceed.
Please, the court, stay. Ladies and gentlemen of the jury, thank you for your attention. We appreciate y'all making yourselves available to hear this case. I've got several thoughts on my mind, but one thing that comes to mind is that they're wanting you to believe that she's dealing drugs. But one thing that I didn't see in anything that was on videos or pictures or whatever, I didn't see a large amount of money anywhere. I didn't see anything other than a $20 bill crumpled up under a credit card case in that RV. She's selling stuff for $100 a pop, $210 a pop, and there's no money. They didn't find any money on her. They didn't find any money stuck in the drawer. They didn't find any money. Drug dealers sell drugs to make money. She didn't have any money. The other thing that's interesting is they're saying that the drugs are in this dresser. If you'll remember, not one of the people on the SWAT team, not one, said that my client was even in the RV when they served the search warrant, right? Because they all had, you know, one or two of them made the comment, you know, so my job is to do this, but then I transition into doing that. All of the transitioning took place after their initial commitment to secure the perimeter, but nobody said, I saw ALISHA Dean in that RV that was in the backyard. All they say is her stuff was in there. The other thing that's odd, and it seems like, I guess at the end of the day, I can say, well, at least I learned something new today. And what I learned is that they can do DNA testing on anything. And they can do fingerprint testing on anything. Just have to have a supervisor's signature. But why should we do that, right? We shouldn't have to do that. Yeah, we should. Society should have to do that. If you're going to accuse somebody of committing a first-degree felony, which is a serious offense, you should have to do that. And every one of them chose not to even consider doing it because they already made an assumption. They already knew. That's not right. Not in our society, that's not right. They think that she's selling drugs, but yet they don't have any proof of an actual transaction. It's just these text messages back and forth. She says that Matthew, whoever, had her phone. We had a witness testify that Matthew had been there, and that was not uncommon for him to use and play with her phone because he knew the password. She said they're not her drugs. She told the cop at the jail, they're not my drugs. She gave a name at the jail, and then ultimately she changed that once she found out the truth the Matthew struck. There were 18 different people milling around when the SWAT team got there. 18 people. She says in her testimony, it's not uncommon for people to come and go through the RV area. Not uncommon at all. For God's sakes, look at that. I mean, the way, the whole setup, it seems like there were just people everywhere. It's just not uncommon. The state even mentioned that there were pictures on the phone of her and others, at least one other, in the RV. So it's not that there's no way anybody else could be in there doing anything. It just seems to me that, you know, and I expect that part of the jury instructions are going to be that, you know, a verdict must be based solely on the evidence or the lack thereof and the law. We don't have any DNA evidence, but we could have. And we don't have any fingerprints evidence, but we could have. And I'm going to change that word, and I'm going to say, I think we should have. We should have known that it was on there, her DNA was on the packaging, and her fingerprints were on there, or it wasn't. That would make a clearer case. Now the state has to say, well, now to prove that she actually had possession of it, we have to show that she was selling it or had knowledge of it or something, all these other things. They had the answer right there in their hands. There's ways for them to get her DNA sample. They even said, they agreed to that. There's ways to get her fingerprints through the system. They turned their back on the slam dunk. I'm asking you to find her not guilty because the state just didn't play the cards right in this one. They should have asked for the additional evidence. Even if it upset a supervisor at FDLE, so be it. But that seems to be all it would have taken to get those two things done. They chose not to do that. I think that we as a society should expect law enforcement to do their job. In fact, I think we should have expected them to follow up with all these other names that come out. To follow up on the phone numbers. They've got a database of people that they've been tracking for years with certain phone numbers and certain names. And not one of them followed up with any of those people or their database. Why? That's their job to investigate, not just to assume. They didn't do their job. And I ask you to find her not guilty.
Rebuttal?
Yes, Your Honor. We got the fact that she was the one in the RV, or one of the people in the RV, from her own testimony. She told us that. At the scene. I was in the RV. I live in the back RV, not the front one. I want to talk about the lesser included offenses. When the judge instructs you on the law, there's going to be lesser included offenses. So you have trafficking and and lesser included offense of trafficking, possession with the intent to sell, and then lesser included of that, possession of methamphetamine. Florida's interesting, because we have trafficking and then sale, manufacture, deliver. Those are two separate crimes, but one is lesser included. The reason for trafficking, why she's charged with trafficking, is because we have a weight. That's what we need in Florida for trafficking, it's weight. For sale, manufacture, deliver, you go on intent, saying she intended to do that. So that's why the lesser included of sale, manufacture, deliver is not the correct charge. It's trafficking because we have the weight. The defense has talked a lot about DNA and fingerprints, and albeit that would be probative, that would not be dispositive like they're trying to say. It would just move the ball. Well, when did she touch the bag? I know her fingerprints are on the bag, but when did she touch it? That doesn't show that she knew that the methamphetamine was there. That just shows that she touched the bag. Same thing with the DNA. It's just moving the ball. The state feels confident in its case, feel that we've proven each element beyond and to the exclusion of reasonable doubt. There was a lot of effort that went into this case. It's been a long time, but we have met our burden. We have reached the third floor of the Taj Mahal down the road. We have beyond a reasonable doubt that ALISHA Dean is guilty of trafficking methamphetamine, 28 grams or more, but less than 200. So I want to thank you for your time and your attention these past 2 days. We could not be here without you. I might have said this in the jury selection. It's pinnacle of democracy. Y'all elect the representatives who pass the law, and then you decide who and when somebody violates that law. So thank you for your civic duty, and best of luck.
All right, please pass out the instructions. All right, ladies and gentlemen, you can read along with me if you wish, and you can take the instructions and your notes back into the jury room with you when you go to deliberate. You're not required to read along with me, but we did provide you with a copy if you wish. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Counsel, I'm turning off the mics at your tables. ALISHA Marie Dean, the defendant in this case, has been accused of the crime of trafficking in methamphetamine 28 grams or more and less than 200 grams. Certain drugs and chemical substances are by law known as controlled substances. Methamphetamine is a controlled substance. To prove the crime of trafficking in methamphetamine, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, ALISHA Marie Dean knowingly possessed a substance. Number 2, the substance was methamphetamine. Number 3, the methamphetamine weighed 28 grams or more. To prove ALISHA Marie Dean knowingly possessed a substance, the state must prove beyond a reasonable doubt that she, A, knew of the existence of the substance, and B, intentionally exercised control over that substance. Control can be exercised over a substance whether the substance is carried on a person, near a person, or in a completely separate location. Mere proximity to a substance does not establish that the person intentionally exercised control over the substance in the absence of additional evidence. Control can be established by proof that ALISHA Marie Dean had direct personal power to control the substance or the present ability to direct its control by another. Possession of a substance may be sole or joint. That is, two or more persons may possess a substance. Lack of knowledge of the illicit nature of a controlled substance is a defense to trafficking in methamphetamine. You may, but are not required, to infer that ALISHA Marie Dean was aware of the illicit nature of the controlled substance if you find that she possessed the controlled substance. You may, but are not required, to infer that a person who sells a controlled substance knows of its illicit nature. If you are convinced beyond a reasonable doubt that ALISHA Marie Dean knew of the illicit nature of the controlled substance and all of the elements of the charge have been proved, you should find her guilty of trafficking in methamphetamine. If you have a reasonable doubt on the question of whether ALISHA Marie Dean knew of the illicit nature of the controlled substance, you should find her not guilty of trafficking in methamphetamine. If you find the defendant guilty of trafficking in methamphetamine, you must further determine by your verdict whether the state has further proved beyond a reasonable doubt that A, the methamphetamine weighed 14 grams or more but less than 28 grams, B, the methamphetamine weighed 28 grams or more but less than 200 grams, or C, the methamphetamine weighed more than 200 grams. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of trafficking in methamphetamine, 28 grams or more but less than 200 grams, are possession with the intent to sell methamphetamine and possession of methamphetamine. Certain drugs and chemical substances are by law known as controlled substances. Methamphetamine is a controlled substance. To prove the crime of possession with intent to sell a controlled substance, the state must prove the following three elements beyond a reasonable doubt. Number one, ALISHA Marie Dean possessed with intent to sell a controlled substance. Number two, the substance was methamphetamine. Number three, ALISHA Marie Dean had knowledge of the presence of the substance. Sell means to transfer or deliver something to another person in exchange for money or something of value, or a promise of money or something of value. To prove ALISHA Marie Dean possessed a substance, the state must prove beyond a reasonable doubt that she A, knew of the existence of the substance, and B, intentionally exercised control over that substance. Control can be exercised over a substance whether the substance is carried on a person, near a person, or in a completely separate location. Mere proximity to a substance does not establish that the person intentionally exercised control over that substance in the absence of additional evidence. Control can be established by proof that ALISHA Marie Dean had direct personal power to control the substance or the present ability to direct its control by another. Possession of a substance may be sole or joint, that is, two or more persons may possess a substance. Lack of knowledge of the illicit nature of a controlled substance is a defense to possession with intent to sell a controlled substance. You may, but are not required, to infer that ALISHA Marie Dean was aware of the illicit nature of the controlled substance if you find that she possessed the controlled substance. You may, but are not required, to infer that a person who sells a controlled substance knows of its illicit nature. If you are convinced beyond a reasonable doubt that ALISHA Marie Dean knew of the illicit nature of the controlled substance and all of the elements of the charge have been proved, you should find her guilty of possession with intent to sell a controlled substance. If you have a reasonable doubt on the question of whether ALISHA Marie Dean knew of the illicit nature of the controlled substance, you should find her not guilty of possession with intent to sell a controlled substance. Certain drugs and chemical substances are by law known as controlled substances. Methamphetamine is a controlled substance. To prove the crime of possession of a controlled substance, the state must prove the following two elements beyond a reasonable doubt. Number one, ALISHA Marie Dean possessed a substance. Number two, the substance was methamphetamine. To prove ALISHA Marie Dean possessed a substance, the state must prove beyond a reasonable doubt that she, A, knew of the existence of the substance, and B, intentionally exercised control over that substance. Control can be exercised over a substance whether the substance is carried on a person, near a person, or in a completely separate location. Mere proximity to a substance does not establish that the person intentionally exercised control over the substance in the absence of additional evidence. Control can be established by proof that ALISHA Marie Dean had direct personal power to control the substance or the present ability to direct its control by another. Possession of a substance may be sole or joint, that is, two or more persons may possess a substance. Lack of knowledge of the illicit nature of a controlled substance is a defense to possession of a controlled substance. You may, but are not required, to infer that ALISHA Marie Dean was aware of the illicit nature of the controlled substance if you find that she possessed the controlled substance. If you are convinced beyond a reasonable doubt that ALISHA Marie Dean knew of the illicit nature of the controlled substance and all of the elements of the charge have been proved, you should find her guilty of possession of a controlled substance. If you have a reasonable doubt on the question of whether ALISHA Marie Dean knew of the illicit nature of the controlled substance, you should find her not guilty of possession of a controlled substance. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed and the defendant is the person who committed the crime. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. The evidence that has been admitted to show other crimes, wrongs, or acts allegedly committed by the defendant may be considered by you, but only as that evidence relates to proof of the absence of mistake or accident. However, the defendant cannot be convicted for a crime, wrong, or act that is not included in the information. It is up to you to decide what evidence is reliable. You should use your common sense in deciding what is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been convicted of a felony or misdemeanor involving dishonesty or false statement? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe her to be an expert. May believe or disbelieve all or any part of an expert's testimony. The defendant in this has become a witness. You should apply the rules to consideration of her testimony that you apply to the testimony of other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. A statement claimed to have been made by the defendant outside of court has been introduced into evidence. Such a statement should be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. If you conclude the defendant made the statement, you must also determine from the evidence whether the defendant's statement was freely and voluntarily made. In making this determination, you should consider the circumstances, including but not limited to whether, when the defendant made the statement, she had been threatened to get her to make the statement, and whether anyone had promised her anything to get her to make the statement. If you conclude the defendant made the out-of-court statement, but it was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to decide a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. We have the verdict form, which will be sent back into the jury room with you, and it states, we, the jury, find as follows as to count 1, trafficking in methamphetamine, 28 grams or more but less than 200 grams. And then it says in parentheses, check only 1. And then you have some options. Option A, the defendant is guilty of trafficking in methamphetamine, 28 grams or more but less than 200 grams. Right underneath that option, it says in parentheses, if you find the defendant not guilty of the main charge, then proceed to the lesser included offenses. And then there are more options for you. Option B says the defendant is guilty of trafficking in methamphetamine 14 grams or more but less than 28 grams. Option C says the defendant is guilty of possession of methamphetamine with intent to sell. Option D says the defendant is guilty of possession of methamphetamine. And option E says the defendant is not guilty. And then the foreperson will date and sign the verdict form. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you have cell phones, tablets, laptops, or other electronic devices in the jury room. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room during your deliberations. Kindly give those devices to the court deputy where they will be guarded while you deliberate. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, were received into evidence, I believe there's a typo. I believe this should say certain items were received into evidence as exhibits. You may examine whatever exhibits you think will help in your deliberations. The exhibits, will be sent into the jury room with you when you begin to deliberate, except for the controlled substance. If you wish to see the controlled substance, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Any objections to the instructions as read from the state or defense?
Not any from the defense.
None from the state.
Thank you. So, ladies and gentlemen, this is the part of the trial that I like the least. One of you is an alternate. For whatever reason, cannot continue through to deliberating. Ladies and gentlemen, the rules are so strict that alternates and jurors, once we've reached this stage, cannot go into the jury room at the same time. So we will need to wait until Ms. McKinley-Coleman gets her things and leaves the jury room before I can let you go in there. And just so our record is clear, all attorneys and Ms. Dean have been present throughout the closing arguments, the instructions, and are still present now. And ladies and gentlemen, I see that it is almost 5 o'clock. I know it is late in the day. The attorneys moved really quickly to try to finish the trial in one day rather than have you come back tomorrow. We will check on you in a little while, probably in about an hour and a half, to see how you're doing if you want dinner. There is no time frame for your deliberations. You can finish as soon or as late as you wish. Okay. All right, at this time, you may begin your deliberations.